Hello, I'm Kevin Mohr. I'm a professor at Western State College of Law in Fullerton, California, where I teach contracts and professional responsibility. I've also been heavily involved with the State Bar in helping the Rules Revision Commission draft the Rules of Professional Conduct. I'm here today to talk about different ethics issues. I'm going to start very generally, and then I'm going to try to narrow down and focus on the specific topic, which talks about general counsel or in-house counsel in corporations or other associations, including law firms. First, let me talk about what are the sources of regulation for lawyers in California. California is unique in the sense that California has numerous sources of regulation. Most other states, the regulation is found almost solely in their rules of professional conduct. California, however, goes well beyond that. California does have the California Rules of Professional Conduct. It also has the State Bar Act, Business and Professions Code, sections 6,000 and following. It has other statutory law, including the Civil Procedure Code, which would have the work product protection. It also has the Evidence Code, where we will find the attorney-client privilege. In addition to these sources, we also have the rules of court. We have case law, which interprets all of the foregoing sources of regulation. We even have common law regulation. For example, before we had a communication rule, we had common law that addressed lawyers' duty to communicate with their clients. Finally, very helpful resources for you are State Bar and Local Bar Association ethics opinions, which try to flesh out the rule and provide you with guidance on how to apply the rules. One thing, all that is the state sources of lawyer regulation, but we can't forget that there are also federal sources of regulation. Primary among those are the Sarbanes-Oxley Act. We're going to be talking a little bit about that later on. And in addition to the Sarbanes-Oxley Act, FTC regulations on advertising. And we also have a thing called the Anti-Spam Act. California has an Anti-Spam Act, sending emails, blasting emails to a lot of people. Lawyers are subject to those regulations. Now, consider the California Rules of Professional Conduct. I'll say this, I'll come back to it later. Our rules of professional conduct are rules of discipline. They provide a basis for imposing discipline. They are a low standard. It's the base level of conduct with which a lawyer must comply or face discipline. Finally, I just want to give a pitch for the State Bar Ethics website. I've been around to a lot of websites around the country in my work with the State Bar, and I can assure you that California probably has the best ethics website in this country. So I strongly urge you just go to the California website, the home page, click on the ethics link in the lower left-hand corner, and you'll be taken to a plethora of resources on legal ethics. Okay, so my focus is going to be on confidentiality and how you should deal with confidentiality when interacting with the general counsel of a corporation or even the general counsel of your law firm, if you happen to be fortunate enough to be in a law firm where you have a general counsel. Let me review a few points generally about the duty of confidentiality and the attorney-client privilege. The two are not the same. The attorney-client privilege is an evidentiary privilege. It's a narrow evidentiary privilege. It exists to assure clients and lawyers that the client can freely discuss the client's matter with the lawyer without fear of either the client or the lawyer being compelled to disclose what they discussed. It doesn't protect the underlying facts. If the client's put on the witness stand, the client is going to have to testify to the underlying facts. But if the question is asked, what did you tell your lawyer about this? The lawyer should jump up and say, objection, that is attorney-client privileged. Well, I'll tell you there are 5 components to whether the attorney-client privilege attaches. First, there must be a client. The client must, in confidence, communicate with a counsel, that is a lawyer in the counsel's professional capacity, seeking counsel, legal advice, or legal services. The duty of confidentiality on the other hand, is much broader. The concept of the duty of confidentiality is that a lawyer must not gossip about his or her client. No matter what the source of information you have about the client, you don't talk about your client. Save your relationship, save your marriage. Don't even talk with your significant other about your client's matters. Okay, let's go and quickly discuss, now that we know the duty of confidentiality and attorney-client privilege, let's address the first issue. And here's the hypothetical. You have a partner named Pear and an associate named Avocado. And they represent a corporation named Cornco. And Cornco is about to file some documents with the SEC, and both Avocado and Pear believe that these documents are making misrepresentations and might even make some false statements in violation of the SEC regulations and the federal securities laws. What are the lawyer's obligations under those circumstances? First thing is, you need to bring it to the attention of the corporation's general counsel if the corporation has a general counsel. And let's assume that happens. You go and talk to the general counsel of the corporation. Let's call the general counsel Garlic. Garlic sees no problem. What do you do under those circumstances? Well, under those circumstances, if you still have a reasonable belief that there's a problem, you can go up the ladder in the corporation. And what do? You go up the ladder all the way to the board of directors if necessary, if you feel strongly enough about your belief. Let's assume you've gone to the board of directors. The board of directors says there is no problem. What do you do under those circumstances? Well, here's where you have a bit of a problem. If you go beyond the board of directors, you're going outside the corporation and you're going to breach your duty of confidentiality. Now, in all the other states, you have pretty much a free pass because every other state has an exception that you can disclose client confidential information to prevent a financial crime, a crime or a fraud that's going to cause injury to a person's financial interest. California has no such exception. We also have the Sarbanes-Oxley Act, which is a federal statute and regulations that have been promulgated pursuant to the Sarbanes-Oxley Act. They state that you may disclose this information. But again, California does not have that same exception. The question is, which wins out, California or the Sarbanes-Oxley Act? Well, from constitutional law, your jurisdiction course, you're probably saying to yourself, well, it's going to be federal preemption. Not necessarily, because the permissiveness of the federal regulation, it's a regulation, it's not a statute. So there's a real question whether the regulation will trump California law on confidentiality. Let's assume that Pear tells Avocado, seal your lips, don't say anything. What's Avocado to do? Avocado has an independent duty. You, as young lawyers, have an independent ethical duty to comply with the law. And if your supervisor is ordering you to do something that you believe is incorrect, you might have an independent duty to go outside. So what do you do under these circumstances? You have to make a determination. Is the resolution that my supervising lawyer made, is it a reasonable resolution of an arguable question of professional responsibility? I can assure you right now that the question of whether you must comply with the federal regulation or with California law is still an unsettled question. Therefore, the supervisor's resolution was probably reasonable. You must comply with the supervisor. If you need questions, you can consult with a lawyer who has, a special knowledge in the ethical area. But ultimately, you're going to have to make the decision yourself. The lawyer can only give you advice, and you will make that decision yourself. I would like to end by just telling you something that a good friend of mine, former retired state bar court judge, once told me and tells everyone, be careful out there. Thank you.